First two charges of count 1 being rape and count 2 being gross sexual imposition are the same as were indicted previously.
Wisconsin and West have checked for injuries. There was someone running through the parade route.
What happens when evil is held accountable for their actions and have to face that music in court? Today's cases will see a satisfying sentencing to these vile and beyond disgusting men, starting with our first case of Matthew Peter. In February of 2022, Officer Matthew Peter would appear in Cleveland court in front of Judge John Russo on account of several charges against him, and his behavior during this time nothing short of vile.
I did, yeah.
Do you know any of the Hannahs out there?
Hannah's no.
That's a pretty big community though.
Yeah, it is.
When did you start with the county?
December of 2019. So.
That's why we haven't seen you.
Right, exactly. Right before the pandemic.
We've seen a lot of you nowadays.
It's true, yeah. And it's picking back up.
You can be seated. If you just check your cell phones, make sure they're silent for us, please.
Yes, sir.
I'm told, Mr. Snatter, from the state that the alleged victim in this case also wanted to speak on bond. Is that correct?
That's correct, Your Honor. She is present via Zoom.
Right, so I just signed on at this time.
Judge, if I may be heard, with respect to...
We'll go off the record for a moment.
Thank you.
Sure. But I did want to just go off the record because this victim, alleged victim, is here. So I just want to make sure there's no video of her.
Exactly. If the audio goes through, do you want the audio? I think I can kill the audio, or we can just leave video off. It's up to you, Your Honor.
Mr. Snatter, do you have a position?
I can have Ms. Kutek
Do you want?
her see if she has an objection to being heard on camera. I might
Do you?
suspicion
Can
she
you
doesn't.
speak to her right now?
Sure.
So why don't you tell her I'm going to sign her on? If she wants to keep her video off, she can.
Okay.
And then when and if she wants to speak. And Mr. Hollow, you're objecting to her, but she's the alleged victim in the case.
She's already judged. We've already heard from her. Her bond's already been set. This was the victim in the first case, not the second case.
I'm told it's the alleged victim in the second case.
Oh, it's the first case.
Hang on, let me hear. Yes.
She is a named victim on this indictment. She is
Oh, I see. It's the re-indictment of the original case as
Correct.
well.
Peter was convicted prior to this hearing once in 2019 for attacking a woman, but had been previously cleared of charges he faced in 2017, which are now more likely to be true.
At this time, you're welcome. So at this time, the lawyers want to make some arguments, so I'm going to let you listen in on the arguments. And then I'll also then make a decision if in fact I'll hear from you or not, because there's some discussion about whether I should hear from you or not. But if you would, for me, just put yourself on silent. Do you know how to do that with your phone? Are you on a phone or on a computer?
Mute, correct?
Yes, you got it. Yeah, it looks like a microphone, and if you touch that, it'll put a line through it. There you go. Yeah, thank you. Thumbs up on that. Okay, and then if I do address you, you just hit that button again and you'll come off, okay? So we're going to go back on the record. So we're on the record. Originally, this case is set for a pretrial on the case that's currently on my docket. That's case 645-563. The court was apprised that the state was going to re-indict that case and add some additional charges to a new case. So the court's been aware of that, as Mr. Hilo, you and your client have been aware of that as well. That new indicted case is case number 659954. And that case, when it was indicted, I believe the parties were comfortable with allowing me to do the arraignment this morning, so that obviously the case is going to stay with the court as well. Mr. Snatter, you wanted to be heard about, in this new indicted case, the alleged victim in case 645-563 is again renamed as counts 1 and 2 of the indictment, I believe, if I'm reading it correctly.
That's accurate, Your Honor.
And then counts 3 and 4 are a new named victim, Jane Doe 2, and a different date of offense. So we now have a 4-count indictment that the grand jury has true billed, again, for today's arraignment. The state, I believe, wants to have the bond discussed again on the record, and also under Marcy's law, has the alleged victim, Jane Doe 1, available to speak regarding the bond.
It's chilling to hear the judge list Peter's indictments, showing all the harm he caused. The victim, however, would not hold back in her testimony.
If I'm correct, you'd like her to speak this morning, and with respect to bond under Marcy's law. And if I missed anything, please make a good record for me. Thank you.
Thank you, Your Honor. That's correct. The alleged victim reached out of her office, asked to be heard. At the arraignment, we had a conversation. She fully understands that this proceeding is, and the purpose of bond is limited to the purpose of bond to secure the defendant's presence at future proceedings and address any safety concerns with the public. And she's fully aware that those are the matters that she wishes to address, nothing about the underlying facts of the case. And she just wants to exercise her right under Marcy's law to address the court when it takes into consideration the appropriate bond on the new case.
All right, thank you. Mr. Hilo, you wanted to be heard.
Your Honor, based on the bill of particulars that were provided in the first case, this re-indictment encompasses those same bill of particulars that were addressed by this victim and the state of Ohio on the original case, which encompassed the bond that was set. And for the purposes of bond, to secure that our client would appear at all court proceedings, to secure that he would not engage in any criminal activity from the onset of that bond to this date, he has complied with that. Your Honor, I don't believe it's relevant just because there's been a re-indictment of that same case. When the court took into consideration, when the bond commissioner took into consideration those facts in setting the bond, and the court followed that recommendation. Even with respect to Marcy's law, I don't believe there's a place at this time for further comment on the bond with respect to this victim.
The lawyers here were referring to Marcy's law, which gives victims of crime equal constitutional rights as the accused and convicted.
All right, thank you. I know that, let's just say this, when he was indicted on the original case, 645-563, I just can't grab the docket of who was in the arraignment room at the time. Obviously, I wasn't in the arraignment room. In fact, I think the case was drawn by another judge to another judge's docket. That judge recused himself and then randomly was drawn to me. So initially, whoever heard the bond recommendation in the arraignment room, I'm not sure if the Jane Doe 1 was present at that time and had an opportunity to speak. And I don't know if you know that either, Mr. Schnatter. I would say this, because it's a re-indictment, it's a new case, and it's, while the first two counts are alleged to be the same Jane Doe 1 as in case 645-563, I do believe under Marcy's law it's a new proceeding, and under the new proceeding, the alleged victims in both counts, or both counts 1 and 2 and counts 3 and 4 would be allowed to speak at the time of the bond. So, Mr. Hilo, I understand your position that while the arraigning judge may have had a chance to hear, I haven't had that chance, and I think under Marcy's law, and because I'm doing the arraignment, I sit differently as an arraignment judge, and so while I'll note your objection, I'm going to allow her to speak in whatever fashion the state wanted her to speak regarding my interpretation of what a bond should be set at regarding this case.
Thank you, Your Honor.
The judge argued that since this was the first time Peter's case reached him, he had full authority to let the victim testify under Marcy's law, leaving the defense powerless.
All right, so regarding this case, Mr. Piter, I'll just have you stand with Mr. Hilo. And, well, let me do this before you stand. Because it's both a pretrial and an arraignment, the parties know that I referred Mr. Piter for a court psychiatric clinic report for competency evaluation. That was done, I think, a request made by Mr. Hilo at the time that we were here for our last pretrial. I did receive that report. I know we shared that report with both parties, the state of Ohio as well as Mr. Hilo. That report is dated June 21st of 2021. Our doctor, Nina Ross, R-O-S-S, in her interview and in her evaluation of Mr. Piter, that it is her opinion with reasonable medical certainty that despite Mr. Piter's present mental condition And she goes on to list that condition that he is able to understand the nature and objective of the court proceedings, and then she gives her medical opinion why. She also opines with reasonable medical certainty, again, that despite his present condition, he's able to assist in his defense as well. And then Mr. Hilo?
Yes, Your Honor.
Okay, thank you. Okay, so then at this time, Mr. Piter, I'll ask you and counsel to stand. And again, as if we were in the courtroom, in the arraignment room, I'll go through the rights that you have and discuss with you the indicted charges, and then I'll hear from your counsel, and then we'll proceed with any discussion regarding bond, and then I'll move forward with setting a bond. Case, of course, it will be reassigned to my docket. We'll have another date set, and we'll make sure we move forward as we have on the prior case, in being consistent with trying to find a trial date that's good on both the counsel's calendars and also being mindful of discovery.
Given Peter's bored expression and his previous dismissal of charges, he likely expected to avoid consequences for harming these women again.
That Jane Doe 1 is present this morning, and I am going to allow her to speak in whatever fashion the state believes they want to present her. I'll note that she's here by Zoom, and I've spoken to her about allowing her an opportunity to speak after I made my ruling. So she is present as well, and I'll give her an opportunity to speak. So, Mr. Hilo, regarding the indicted charges of your client, Mr. Piter, anybody who comes in, we've talked about this a number of times regarding your case that was indicted originally. We talked about it so many times because we had you waive that speedy trial while we were in the pandemic, and wanted to make sure that we weren't violating any constitutional rights. Here in the state of Ohio, you have a right to a speedy trial. You have a right to a trial to a jury of 12, and you can also choose to give up the jury looking at the disputed facts and try the case to me as your judge. And that's unique in Ohio, or unique in the United States, but here a right for you in the state of Ohio. Once you choose whether it's a bench trial or a jury trial, the burden is always on the state of Ohio, Ms. Kupak and Mr. Schnatter. They would have to prove your guilt beyond a reasonable doubt. So in doing that, they would call witnesses to testify. You have a constitutional right through Mr. Hilo to examine and cross-examine the state's witnesses. When the state has completed their case, you then also have a right through Mr. Hilo to call witnesses. He obviously, a well-seasoned counsel here in this county and this court, would subpoena witnesses. A subpoena is a notice of someone being asked to come in and testify. If Mr. Hilo or Mr. Schnatter were to issue those subpoenas, they would then demand the appearance of that witness. A right that you have is, once those are issued, if a witness fails to appear, that I have the ability to arrest the witness. So I can force the witness, compel them to come up to this witness stand and testify. You have a constitutional right, Mr. Piter, to remain silent.
Later that month, Peter would have been sentenced to a year of probation and was forced to register as a Tier 1 sex offender.
And no one could ever comment that you didn't testify. So neither the state, Mr. Hilo, or myself could force you to testify or use it against you. Those are your constitutional trial rights as you stand here before me today on new case 659954. You have a right to counsel, and obviously counsel has been retained and he'll continue to represent you in this matter. You have a right to have these charges in your possession and know those charges for more than 24 hours. You have a right to have me read the indicted charges to you if you don't understand them. And I think, as noted for the record, those first two charges of count 1 being rape and count 2 being gross sexual imposition are the same as were indicted previously. There are 2 additional charges of rape dating back to the alleged offense of May 1st of 2017 to May 31st of 2017. And those are 2 additional charges. So if you don't understand the charges, I could explain those charges to you as well. With respect to today's hearing, Mr. Hilo and the indicted charges that have been handed down by the grand jury, those were handed down on June 1st by the grand jury and processed in the clerk of courts on June 2nd. Mr. Hilo, with respect to that these new charges, I'll ask how your client would like to proceed today.
Peter's casual reaction to the horrifying charges shows a psychiatric evaluation wasn't needed. He knew the nature of his crimes and simply didn't care.
24 hours, waive reading of the indictment, waive any forms of defect in service, enter a plea not guilty, and ask that a bond be set.
Okay. With respect to the bond on this case, I'll hear from the state of Ohio. I'll hear from you with respect to the setting of the bond, and then I'll go ahead and make a ruling on setting that bond here this morning. So, Mr. Schnatter, I'll hear from you.
Thank you, Your Honor. And I was inquiring whether or not there was a recommendation from the bond commissioner. I haven't heard of one yet.
When we inquired of the bond commissioner, there was an original bond that was posted that was asked to be transferred to this case as well. 10% cash, no contact with the victim.
And prior to my addressing the court, I'd asked the court to allow the victim who's present at the arraignment today to address the court.
Yes. So at this time, again, for the record, Jane Doe 1 is present, and I'll just ask to hear from you with respect to any matters regarding the bond. I'd also ask, I'll ask you a question when you're done speaking, but if you want to go ahead and unmute yourself by touching the button that I discussed with you this morning, there you go. So I'll hear from you at this time.
Finally, the judge would give the victim to say her piece on Peter's case.
Bond should be higher because $20,000 is not enough. He is a safety concern to the community. What if there were more victims between 2017 and 2019? How about he has been out on bond? What if he has been actively on Tinder? Who knows what he is doing? Can he be on house arrest or possibly in jail?
All right, thank you for your comments. Let me ask, I know that prior bond had a no contact order. I would have heard from the state of Ohio if that no contact order was violated at all, but I'll ask you as well, just to verify. There was a no contact order and you are the named victim.
If Peter violates the terms of his probation, Judge Russo said he will spend 1 year behind bars. Peter resigned from the force effective February 9th, just 2 days after he was convicted of 2 counts of gross imposition. Peter was out on bond ahead of his sentencing, but was required to wear a GPS tracker. However, the next case included the hearing of a man guilty of a crime so horrific that it made national news.
Wisconsin and West, I'm checking for injuries. There was someone running through the parade route.
In November of 2022, Darrell Brooks was on trial for the unimaginable crime of running his vehicle into a Christmas parade in Wisconsin the year before, resulting in a number of casualties. Given the nature of his crime, his behavior in court would not be any better.
The thing I will ask you to do is to state your first and last names for the record and spell each.
My first name is Jeremy, spelled Jeremy. My last name is Phillips, Philipps.
Thank you. Go ahead, your witness.
Thank you. How are you employed, sir?
I'm employed with the City of Waukesha Police Department.
And how long have you worked in law enforcement?
I've been in law enforcement for a total of 14 years next month.
All with the City of Waukesha?
I have about 5 months with the City of Dodgeville Police Department in Wisconsin. The rest has been with the City of Waukesha.
Sir, I'd like to direct your attention to the date of November 21 of 2021, please. Were you working that afternoon?
I was working that afternoon, yes.
What was your duty or assignment?
I was assigned a normal patrol beat, squad area 216 with the City of Waukesha on a 11 a.m. to 9 p.m. shift.
Were you aware there was a parade taking place in downtown Waukesha that afternoon?
I was aware that there was a Christmas parade downtown Waukesha.
Were you directly assigned to work the parade?
I was not assigned to work the parade.
You said you were one of the officers that was just involved in general patrol of the city that afternoon.
That's correct, yes.
To direct your attention to time around 4 o'clock or 4:30 in the afternoon, do you recall getting dispatched to Frame Park?
I do recall being dispatched there, yes.
Do you know the exact time you were dispatched?
I believe it was 4:52 p.m. approximately there.
Okay. And where is Frame Park located?
Frame Park is rather large, but it's generally located in the downtown area off of White Rock Avenue and Baxter Avenue.
What was the nature of the complaint you were responding to?
I received a complaint to respond in emergency fashion, which means light and siren, for subjects fighting in the park with a knife allegedly involved.
The hearing began with the testimony of an officer who was on patrol during the day of the crime, likely so he could testify against Brooks.
That they started trying to tell me that their friend had been assaulted, that information came over the radio on the primary dispatch channel that something had happened downtown and somebody had been hit. So at that point, my attention started to get a little bit diverted because hearing that on the radio is not something that just happens every day. That perks you up pretty quickly to figure out, that could be a serious injury, that could be more officers needed, something that affects. That took my attention away briefly. The calls on the radio at that point were 1078 after 1078 after 1078.
Okay, what does that mean?
So 1078 in law enforcement jargon is officer needs immediate assistance right now, all available units. As that was being called multiple times, other people were coming on the radio and stating there were subjects down in the street, then it was 10 people down, then it was 15, then it was to 30 or 40. And I had to make a decision at that point, speaking with the subjects, particularly the one who appeared to be involved and the most injured, who was not being cooperative with me, that the greater danger and the clear and present threat that was happening downtown had to draw my attention. I had to leave. I leave the area. I tell her I'm sorry that I had to go. I went down White Rock, navigated float traffic, went down East Main Street in a westbound direction, and eventually came to East Main Street at Barstow Street, where I exited my patrol vehicle.
Officer Phillips detailed his actions that afternoon about the information he received of Brooks running people over downtown, when Brooks would raise his first objection in this trial.
Do you recognize this, or do you want us to play it for a few seconds?
I recognize what I'm looking at.
Okay. Do you believe this to be a truthful and accurate recording from your squad video that afternoon, sir?
I haven't listened to it at this point, but I would believe if it's from what I'm looking at, it would be accurate to my squad video, yes.
Okay. And you ultimately saved your squad video and submitted it to be used as evidence in this case, correct, sir?
Yes, I did.
All right. And this is a clip from that squad video?
It appears to be, yes.
Okay. Move to admit and permission to publish Exhibit 6, please.
Yeah. What is the grounds we haven't seen? What's in the video?
Your objection is noted. It is overruled. Exhibit 6 is received. Permission to publish is granted.
All right, so for the record, this clip is about 6 minutes long. It exactly ends at the 5:59 mark, but we're gonna play it through, Officer Phillips, and I may ask Ms. Gussie to pause at times so you can kind of describe what's going on in the video, but if you can just orient us what we're looking at right now, please, before we start playing.
Multiple injured, man in gas bar. Give me as many ambulance as you can to man in gas bar.
Okay.
Only dispatch, I had shots fired, Wisconsin and West. I'm checking for injuries. There was someone running through the parade route at a high rate of speed. 3206, 1078, 1078.
Okay.
102! It is 1078! We have about 10 to 15 people down on the street!
Phillips would reveal footage from his squad car that revealed the moment Brooks ran his SUV, as can be heard from the officer's radio, a chilling voice of panic.
There's still floats in the parade. I think there was a lot of people that didn't exactly know what was happening in front of them. When I got to Barstow and exited my patrol vehicle and you saw me running down towards the center of the street, at that point I was just trying to assist any officer, EMS, civilian individual that was around, and it was just mass chaos, carnage everywhere.
Did you attempt to render aid to some injured individuals?
There was approximately 2 to 3 individuals I can remember talking to directly. They were all members of the band. I don't know which band it was. It was one of the high school bands just west of Barstow on Main. There was a number of them laying in the street, obviously injured. I had face-to-face contact with a few of them laying on the ground. There were parents screaming at me to help their kids. I did what basic measures that I could take as far as emergency life-saving goes. I checked pulses. I asked them to squeeze my finger, asked them what hurt, what they could move. The 2 or 3 I talked to could still move, they could still talk, they could tell me what hurt. There were multiple people standing around them also providing aid. At that point, some of the radio traffic that I was picking up on, I was gathering that potentially a vehicle had driven through the parade and hit some of these individuals. I contemplated throwing some of these people in my patrol vehicle and trying to get them to a hospital. However, my vehicle just simply isn't equipped to have that kind of space or room to do that, given the fact that I didn't want to try to move anybody unnecessarily that would have caused further damage to them, especially if somebody's involved in blunt force trauma such as a car crash. I said, hey, if you're doing fine right now, somebody will be by shortly, we'll get you an ambulance, just hang tight where you are, and that's basically what I had to ensure at least the 2 or 3 people that I came across. The third person I came across was also a band member. She was a female. Her leg was obviously injured. She was being held upright by a couple of adults, and I asked her what was wrong, what was hurting, if there's anything more serious with her as she was being held up. And she said, officer, I saw what happened, I saw who did this, and I said, what can you tell me? And she said, a red SUV sped through the parade and did this.
And so finally, the officer proved his testimony, confirming that it was Brooks's vehicle that injured and killed so many people. However, Brooks would react poorly, showing the same attitude that got him in court.
These 3 injured individuals you spoke to, would you describe them all as being about teenage years?
Objection.
Overruled, he may answer.
These are the grounds, Your Honor.
Overruled, he may answer.
So is he gonna answer to the question to
Yes.
the prosecution table or to the jury? I'm not sure. He's looking at them answering the questions, but they're not answering the questions, asking the questions.
You may answer the question, sir.
The 3 individuals that I met with initially had band uniforms on, and it was my understanding that the band from that vicinity right then and there was a high school band, so I would place them all at teenage age range.
Okay, thank you. Were you aware that at some point a person was taken into custody in the 500 block of Elizabeth Street that was related to this incident, sir?
Objection, irrelevant.
Overruled.
I was made aware a little while after my involvement directly in the downtown area, yes.
Did you learn the name of the person who had been taken into custody?
Yes.
What was that name?
I knew from radio traffic at the time that it was a Daryl Brooks. I didn't know the date of birth or middle name or anything at that point.
Daryl would take issue with Phillips looking over at the jury from time to time, trying to distract from Phillips's testimony, which Daryl realized would fully prove his guilt.
And did you learn of any complaints that have been filed by Ms. Patterson in the past to other police agencies?
Objection, irrelevant.
Overruled, he may answer the question that's being posed at this point.
I did conduct some more investigation after my involvement in the entire mass casualty incident. When I went back to the police department afterwards, and I was able to verify that Erica Patterson had been involved in other police cases outside of Waukesha.
And specifically, could you find anything linking Ms. Patterson to the defendant, Daryl Brooks?
Objection, hearsay.
Overruled.
I did find information through our reporting system and other law enforcement sources to directly link Erica Patterson to Daryl Brooks, yes.
And did that information also directly link Daryl Brooks to a vehicle described as a red SUV?
Yes, it did.
Officer Phillips was dealing with an Erica Patterson before he learned about the mass casualties, and later confirmed she was actually involved with Brooks.
I don't have any other questions for this witness at this time, Your Honor.
All right, thank you. Mr. Brooks, you may start your cross-examination.
I noticed, Officer Phillips, you are in uniform this afternoon. Were you scheduled to work today?
Yes.
So it would be fair to say that you would be on duty as of now if you weren't giving testimony in this matter.
I would be on duty right now, yes.
It would also be fair to ask if it would be fair to say that you giving testimony right now, you're still getting paid for it?
I am currently employed by the City of Waukesha Police Department on a working patrol shift, on a normal shift for myself, yes.
So with that, would it be fair to say that you are getting paid right now as we speak?
Yes, I'm getting paid right now.
By whom?
Objection, relevance.
Sustained. Next question.
Were you subpoenaed by the plaintiff in this matter?
Can you rephrase the question?
Were you subpoenaed to testify here today by the plaintiff?
Can you explain it in another way?
That was pretty clear. Were you subpoenaed to testify by the plaintiff in this matter?
I was subpoenaed by the Waukesha County Prosecution's Office to testify in this matter.
Brooks had opted to defend himself in the trial and would try to use nonsensical tactics with Officer Phillips in a hilarious attempt to somehow undermine his role as a witness.
Is the Waukesha County Prosecution's Office the plaintiff in this matter?
Objection, irrelevant.
Sustained.
Do you know of any plaintiff in this matter?
Objection, irrelevant.
Sustained.
Have you ever seen the plaintiff in this matter?
Objection, irrelevant.
Have you ever talked
Sustained.
to the plaintiff in this matter?
Objection, irrelevant.
Sustained.
Why are you continuing to look at parties that are not asking the questions?
Objection, argumentative.
Sustained.
So would it be fair to say that you do recall the commentary of the interview?
I'm sorry. Now I will object as argumentative, Your Honor.
Sustained. What I would say, Mr. Brooks, is the use of the word commentary mischaracterizes the evidence. It's argumentative.
So it would be fair to say that you do recall what was said after already saying you don't recall.
I object. It's argumentative.
Sustained. Rephrase your question.
Brooks quickly proved himself to be incompetent in his own defense, as each subtle attack he attempted on the officer would be repeatedly dismissed. On the more fortunate result of Brooks representing himself, he would receive any mercy with his sentencing. Doro also imposed sentences totaling hundreds of years for the remaining 70 counts on which he was found guilty. She sentenced Brooks to 17.5 years for each of the 61 counts of first-degree recklessly endangering safety with the use of a dangerous weapon. You have absolutely no remorse for anything that you do. You have no empathy for anyone, Doro said. Frankly, Mr. Brooks, no one is safe from you. Let me know in the comments below. And if you like the video, subscribe so you can take advantage of the next one we have in store for you. Thanks for watching. This is Detective Mystery, signing off.